You are listening. Happy, healthy, successful Kleesman.
Hello, everybody. This is Happy, Healthy, Successful Kleesman podcast, and this is Tamar. I'm back with my guest, Keijo.
Hi.
Hi, Keijo. How are you?
Fine.
So last time we talked about your background, what you do as a lawyer, as an entrepreneur, as a teacher at the university. So today we want to go a bit deeper in the subject of your training courses, which is about risks related to business and joint ventures and so on. So our listeners would like to know a lot about this topic, I'm sure. So firstly, I wanted to ask you about this metaphor you have used, that you compare starting business to falling in love. That's very interesting. And we wanted
That's real life.
Yes. So we wanted to hear from you more about what you mean by that.
Well, if you have a business idea and if you think that's the best idea, you are, wish to save the world, wish to buy a Ferrari, whatever, you think your idea is the best and it will give answers all to your problems and questions.
You're high.
Or falling in love.
Yeah.
You don't see the risks, you don't see what's negative about it. And also if you have a business partner, again, you have found your business partner who usually always seems ideal for your company. For example, he or she is very good in marketing or, in IT field or whatever. So, and this is where you feel that you just want to start. You have an idea, you have a team, and you will start your business. And maybe everything goes well, a month, 2 months, even a year. But if you will then have some problems, the question is that if you haven't thought about it at the beginning of your business when you started, then later it is very difficult to change something. For example, if you have two friends and you are starting a business together, which means that, and you have the equal shares, it means that if some person, member of the board or shareholder, is not participating as much as you think, then this is quite impossible to get that person out of the company if you don't, for example, have a shareholders agreement and don't have that kind of agreements. So that's the problem I see every day with my clients. I have also had some personal experiences, negative experiences with the partners.
Oh, I imagine.
Business partners. And so this is something that people don't think about it. They just feel that that's the right idea. They wish to continue. That's the same with falling in love. Mm-hmm. So right person, let's move on together. And if the butterflies are gone, then you will see that it's not so perfect as you thought would be.
I see. Thank you. That's very interesting. And I wanted to also ask, what's harder, starting a successful business or keeping it successful long term?
They are both very difficult because if you start a business and it appears to be successful, then your competitions will see what are you doing, what are you doing good, what are you doing bad. So they can also learn from that and take away your clients. So keep the business going successfully. Well, I would say establishing a company and making it successful even can be easier than keeping it successful. Because if you start it, you have some goal. You want, 1,000 clients, million clients, whatever. But to keep them, it's more tricky, because for example, if you have 10,000 clients, what was your goal? Then I think this is not the outcome that you are happy with in a longer period. You wish to see a growth, and the question is, the ideas you have helped you to have 10,000 clients. Mm-hmm. But you need new ideas to have 20,000 or 100,000 clients. So this is something that you have to deal with every day. You have to think about it every day. So that's the hard part of making business.
I see. there are many risks out there when it comes to starting business, keeping it successful, as you just explained. But are there some kind of companies that are more risk prone, so to say?
Well, mainly my training is about personal relationships, which means, and especially shareholders agreement. Because yes, there are a lot of problems. You run out of money. You will have a new company in the field who is taking away your clients. It can happen, but I cannot help in those matters. My field is law, and I mainly see a lot of legal risks. You don't have contracts. Where is the intellectual property of the company? Are the shareholders owning it? Or, for example, if you have some logo, very simple, or the name, do we have some contract that the shareholder who composed the name or the logo or whatever have given this intellectual property to a company? If you don't have that kind of contract, and if you have a dispute between the shareholders, then you may discover that the company is empty. All the intellectual property, which is very important these days, are owned by the shareholders, and if they are not happy to work together, then the company is empty and basically must start from the zero, which is not very good.
What are the steps then that the company owners, business owners, beginners can take in the very beginning to avoid such disaster in the end, to minimize risks of failure?
Well, also one of the problem is that if you have a dispute between the shareholders, it is impossible to make agreements, or they are not very good agreements. So my recommendation is, if you start a business, if you have a business partner, think about their tasks, what they have to do, how much they have to do, what are our goals. Do we have to I don't know, invest 20 hours a week in that company for 1 year, for example? Write it down. Compose a shareholders agreement. If you have it, at least you have some paper, a contract, where you can say that, Keijo, your obligation was to work 20 hours a week for the company, but you have done, I don't know, 1 hour, 10 hours, but less. If you don't have it, then it's very difficult to say. But also what I wanted to say, if we think about new companies, I would say that we have 3 types of different companies. The easiest company is a company when we have one person who has the idea, who has money. He or she will hire the people who are necessary, will buy the equipment what is necessary, and will continue. And usually we don't have problems. Yes, he or she can run out of money, or the idea is not working, but still, legal risks are very slow. The second type of company is where we have people who have their special skills. For example, we have one person dealing with the marketing, one person dealing with the clients, one person dealing with the service they are providing, or things like that. And usually this is also a business, or at least can be a business, where we don't need a lot of money, not a lot of investments, which means that it is important to have agreement that they are willing to participate for at least some period of time. If everything goes well, the company is successful, then they have not enough resources to hire people, they have clients, and they can continue, even if at least some members of the initial team are leaving or not participating as much as they started. And this is the main target group of my training. So people who are starting business together. And the third one is a classic startup. We have people, we have an idea, but we don't have the money. And startup, as much as I understand it, is a classical company who don't have money to hire people, to buy equipment, which means that we need money outside from the company. We need investors. And if you have a professional investor in your team, then this training is not for you, because you have the investors that's telling you the same story that I'm telling you.
I see.
But until the point you don't have investor in a company, this is very important, because if I'm, for example, counseling investor who wants to invest in your company, then I will ask, where is the shareholders agreement? Where are the contracts about the intellectual property that we spoke about, and things like that. So be prepared that if you have an investor, the investor, professional investor, wants to see that everything is correct, at least on paper. You have all the agreements, and a good agreement is not just a paper, a contract. The content is very important. For example, if you have a contract that says that okay, I have to deal with marketing, and that's it. 1 hour a day, 1 hour a week, 1 hour a year. So that's the question. So you may have a contract. You may use a very good draft from, I don't know, some webpage. Very good, legally, very correct contract. But the question is, the things you will add, especially all the obligations and things, do we understand it on the same way? You will read it, you will understand it one way, I will read it, you will understand it on the second way, we will go to the court and the court will read it and understand it on the third way. It's not a good contract. So this is something that I focus on my training, to know what is important to regulate, when to regulate it, and things like that. So if something goes bad, there are things we can prevent and things we cannot. And to have a legal strong background, this is something that we can prevent.
Okay, so you talked about these different kinds of situations when one person can start a company with all the money they already have, or when people are partnering up, or startups, which are very common in Estonia, I can see. So let's focus on people who are partnering up. And that's also subject of your training mainly, the audience of your training. Why would anyone want to partner up with other people who they may not even know? What are the benefits of that, except for the financial part, perhaps? Can you tell us about differences between going solo and partnering up with others, and what would be the advantage? Why would it be a good thing to do, so to say?
Well, the question is, if you have finances to hire people, then it's the easiest way, because you are not giving away your shares. You will hire people, and they do the job, get every day, every week, or every month paychecks, and all the profit goes to you. But if you don't have that money, it means that to start a business, usually one person is not enough. It can be. It's a small business. For example, attorney can work alone. I can do a law firm myself, deal with the marketing clients and everything. This is also one of the options. But if you wish to have a larger business, you need somebody dealing with the marketing. You have clients with different kind of questions. You need one person dealing with the clients. And for example, you need a lawyer dealing with the legal questions. And then you have some service you're providing. You need people who are actually providing services, who are bringing money to a company. So, well, it depends. Yes, in some cases you may have, it may be enough to have only one person in the company who deals with everything. But this is a very, very small company. And if your goal is to establish a larger company, then you need different people dealing with different things. And if you don't have money to pay for them, you need to have partners who are dealing with different type of things that are necessary.
And to get back to the topic of the risks associated with this venture, joint ventures, what would be the most, in your practice maybe, what's the most common mistake people make, and what is the most common risk associated with that?
I would say that we have two types of problems. One of the problem is when you start a business together with a person who you don't know. So yes, you may have information that I don't know, Keijo is very good in law, and maybe he can do something law stuff in our company, but you don't know who I am as a person. So if I provide you a legal service, well, I may act a bit different when I'm a business partner with you. Maybe I want to dominate a lot. Maybe I don't like to work at all, and also just wait for the profit. You don't know the person. So this is the main risk.
Right.
And again, this is where the very good shareholders agreement can help, because if you discover that Keijo is not worth to be a shareholder anymore, then at least you can get me out of the company. If you don't have that kind of agreement, then I'm stuck. You are stuck with me in that company, so you have to decide whether to continue, and you will invest your time or knowledge in that company, and you know that there is a Keijo who is not doing anything, but also wants his share of the profit. Second problem is if the person is a friend with you. And I would say that this is, some of the cases is even a larger problem, because doing a business together is completely different relationship compared with being a friend with somebody.
Yes.
So there are conflicts, and also if you have been a friend, now one of them is a boss and second one is not, so again that kind of problems can occur.
Yeah, the dynamics can
Yes.
change
Yes.
in friendship after, so
And you may end up that you don't have a friend and you don't have a business partner also. So, but
yes.
still, if you don't have finances, you cannot hire people. You will choose the people to do business with together, or the people who know. You cannot, well, you can, but it's very difficult to find people who you don't have any connection before. So yes, you can. What people do, you go to different startup events. You will speak with the people. You will, what's your field of activity and so on, and you can find them. But as I told you, there are new risks that you have to eliminate also.
I see. So trust policy is not exactly what what would be advisable, rather going legal.
I'm attorney. I deal with problems.
Yes.
I don't deal with companies where everything's perfect and they have no contracts and everything's fine. They are not on my desk. On my desk, I will see companies where we have a lot of problems, and then I will see that we don't have contracts and properties somewhere and things like that. So yes, it is possible that you will do a business with your best friend. You will have 0 contracts and everything is fine, and you are very rich and famous eventually. Can happen, but my
you
job
probably
is
won't see those cases as much.
I don't see that kind of cases. Yes.
Okay, so when it
But
comes,
also, what is important, if you have the best friend and everything's fine, and in some point you think that you need investments, then professional investor still starts asking those questions. And even if everything has been fine until that point, this is also a point where it's possible that if investor starts asking those questions, it can change the relationship between the partners, because then they start to think about it. And again, if we don't have written agreements at the beginning of our business, it can be a problem in the future also. Still, I'm very pessimistic about it.
I see, yes, but you've seen probably a lot of messed up cases, so to say. I wanted to ask about this written agreements you were just talking about when it comes to partnering up with strangers or even your friends, and you decide to go legal to protect yourself for the future because you understand all the risks related. How can you make sure that you are protected? You can probably never be 100% sure, but how can you minimize the risks again when it comes to making these agreements? What's the first thing you should keep in mind as a business owner, as a shareholder?
Well, in my point of view as attorney, what is a good contract? Good contract is a contract what describes what are actually being done. So if you are thinking about composing, for example, shareholders agreement or whatever contract, think about what are the most important things that the contract must regulate. Because me as attorney, I will add all the legal part, but I don't know what are, for example, in the shareholders agreement. I don't know what are your agreements between the partners. Fields of activity, marketing, business, business clients and things like that. And also how much time or finances or whatever somebody has to invest in that company. For example, maybe the task of one partner is to compose a web page, what has some kind of functions and things like that. It can be one of the tasks of one of the shareholders, and that's it. We'll have a web page, and that person doesn't have to do anything anymore, because at the beginning to starting a company, having a free web page, this is enough to give shares to some person. But again, if you have a web page that is not working or don't have the functions we need, then the question is, do we have some contract that regulates that question? If we have a shareholders agreement that says that Keijo must make a web page, and I have done some kind of web page, well, I have fulfilled my obligations. But if it's not good one, and as a result of a bad web page, we are losing clients, then this is bad for the business. But you cannot say to that partner that he or she had done something wrong, because my only job was to make a web page, and factually we have a web page. So that's the problem. So think about what are the most important things, and I can say web page, composing a web page is one of the most difficult contract. Is it just a contract where you will buy a web page, making a web page from some company, or is it in a partners agreement, shareholders agreement? There are a lot of questions that it is very, very, very difficult to regulate in the contract. Visual, is it nice or not? Are the colors correct or not? It's so this is the questions that we need to discuss.
All right, thank you. And last question would be, how would people benefit from your training course, and who would be your main audience?
If you wish to start a business with another person, with a business partner, this training is meant for those people, and both of them, to understand what needs to be regulated legally at the beginning of your business. And it can save you a lot of money eventually, because if you have done business, I don't know, a year, and you have problems and you start solving them, you may discover that it is quite impossible to solve them because you don't have the agreements that are necessary. And also, if you don't have money to visit an attorney and pay thousands of euros to them to compose a shareholders agreement, I also give recommendations what must be in that contract. And basically, it is possible to compose a simple shareholders agreement, what is still working, for free. You don't have to pay thousands of euros to attorneys. It is still better than nothing. But yes, I can also give you advice what should be in that contract, and if you visit attorney later also you have prepared everything, then again this job is much easier for an attorney, and it's also cheaper, because if usually what I do, I get some information from the client, I will compose a contract, and I have a lot of questions inside that contract, which means that I will send you a contract, and then we can start discussing all those problems that I see, what I don't understand, or what I see, what is missing, what must be changed, and it takes a lot of time, and the client is paying for that. So if you have prepared it, and answered all those important questions, and you will give this information to an attorney, then it's much easier to compose a shareholders agreement, because basically all the shareholders agreement are, at least at some of their parts are the same, and based on the client's wishes and the information we get from the client, we'll change some parts of the contract. and again, you will save a lot of money, and hopefully it will help not to have that kind of problems in the future.
Amazing. So we are ending on a more optimistic note now. I hope our listeners enjoyed this episode. I think it was very interesting, very informative. So thank you, Keijo, for being with us. And thank you everyone for listening. Have a great day ahead. Bye-bye.
Thank you. Bye.
You were listening. Happy, healthy, successful Kleesman. You can find more information on our website, kleesman.com.